Good morning, ladies and gentlemen. My name is Yasin Hassan and I am from Merchant Tech Capital. The reality of market abuse is an issue for listed businesses the world over. Whether accidental, intentional, or through sheer ignorance, insider trading is a punishable offense and one which can easily be avoided if you remain aware of the rules, regulations, and ensure that you are being advised accordingly. Understanding the relevant legislation and regulations that you must follow, as well as the potential pitfalls and the role of the boards in ensuring that businesses continue to practice in a legal manner, are all essential, especially as the standard for ethical practices seem to be rising. We are joined by Annelie De Bruin from the JSC, and she will take us through her presentation entitled Issuer Regulation Market Abuse. Thereafter, I will be discussing price sensitive information. I hope you enjoy.
Good morning, ladies and gentlemen. Today we're going to look at market abuse. We're going to look specifically at what is market abuse. We're going to look at the impact of market abuse on market integrity. Then we're going to look at insider trading, types of prohibited trading practices, as well as false statements. Section 10 of the Financial Markets Act prohibits three forms of market abuse. First, insider trading, then prohibited trading practices, as well as false, misleading, and deceptive statements, promises, and forecasts. Now let's look at the impact of market abuse on market integrity. One of the main objectives of the FMA is to increase confidence in South African financial markets by requiring that security services be provided in a fair, efficient, and transparent manner. Investors lose confidence in a market which lacks integrity because of actual or perceived unfair or abusive practices, which results in some market participants having unfair advantage over others due to their access to price-sensitive information, or market prices not being a reflection of normal demand or supply due to manipulation, or investors making investment decisions based on false or misleading information. In terms of Section 77, the definition of inside information is it means it's specific or precise information which has not been made public and which is obtained or learned as an insider, and if it were made public would be likely to have a material effect on the price of value or any security listed on a regulated market. Let's look at what's not defined in the Act. The word precise is not defined in the FMA. So we found a definition in the European Court of Justice that basically states that precise is the information indicates a set of circumstances which exists or may reasonably be expected to come into existence, or an event which has occurred or may reasonably be expected to do so, and the information is specific enough to enable conclusions to be drawn as to the possible effect of that set of circumstances or that event on the price of a share. So that's what we could find in the European Court of Justice. Material is also not defined in the FMA. So we found a definition in the US securities laws. And it basically states that information is material if a reasonable investor is likely to consider it significant in making an investment decision, or if the information is reasonably certain to have a substantial impact on the price of the company's securities. Now let's look at what is defined in the Act. We've got a definition for securities, and that includes shares, bonds, derivatives, participatory interest in collective investment schemes. And regulated market is also defined as domestic or foreign market. Now let's look at when is information made public. In terms of Section 79 of the FMA, information is made public once it's published in accordance with the rules of the regulated market. And in terms of the JSE, our rule states that it must be published on SENS. Also in Section 79, it's made public in records which by virtue of any enactment are open to inspection by the public. For example, court records, when the information can be readily acquired by those likely to deal in any listed securities to which the information relates, or of an issuer to which the information relates, or the information is derived from information which has been made public. Definition is in Section 77 of the the FMA, and it basically states that an insider means a person who has inside information through being a director, employee, or shareholder of an issuer, or having access to such information by virtue of employment, office, or profession. Now, just an example, an auditor that is busy with an audit in the issuer, of the issuer, and that auditor, gets hold of price-sensitive information or inside information that's not been made public yet, that auditor then becomes an insider. Or where such person knows that the direct or indirect source of the information was a person contemplated in paragraph A. In other words, he got the information from a director, an employee, or a shareholder of an issuer. Now let's look at section 78, which deals with insider trading offences. 1A of section 78 states that an insider who knows that he or she has inside information and who deals directly or indirectly or through an agent for his own account commits an offence, an insider trading offence. In terms of 1B, a defence that can be used by such a person that committed the offence, if the insider proves on a balance of probabilities that he or she only became an insider after he or she had given the instruction to the authorized dealer to deal, then you can use that as a defense. Another defense that you can use is where this transaction was between parties with the same insider information. The trading was limited to that parties. They all had the same information, was limited to those parties, and the transaction was not aimed at securing a benefit from exposure to movement in the price of the security. Then you can use that as a defense for insider trading. In 78.2, another offense is when an insider who knows that he or she has inside information and who deals directly on behalf of another person. So you will recall the first offense was when the insider traded on his own behalf. This one, the insider is trading on behalf of another person. So the defense that insider can use is the insider is not guilty if they prove on a balance of probabilities that they are the authorized user, and they were acting on specific instructions from a client and did not know that the client was an insider at the time. Another defense is where the person that gave the instruction only became an insider after he gave the instruction. And the third defense is, as in the first defense, was where the person that was dealing was transacting. That person was transacting with a person with the same inside information, and the trading was limited to parties with the same information, and the transaction was not aimed at securing a benefit from exposure to the movement in the price of the security. Then you can use that as a defense. So the third type of defense or offense is any person who deals for an insider directly or indirectly through an agent in securities listed on a regulated market to which the inside information possessed by the insider relates, or which are likely to be affected by it, we knew that such person is an insider, commits an offense. A person is, despite paragraph A, not guilty of any offense contemplated in that paragraph if the person on whose behalf the dealing was done had any of the defenses available to him or her as set out in subsection 2. So that's where you only became an insider after you gave the instruction, or the deal was between parties with the same information. Another insider trading offense is where an insider who knows that he or she has inside information and who discloses such information to another person commits an offense. This is an important one, guys. You haven't even traded yet, but you've just given that information to somebody else. Then you commit an offense. Now, the only defense for that is that you can prove on a balance of probabilities that you had to disclose the inside information because it was necessary to do so for the proper performance of your function of your employment, for this issuer. And an example of that is where the FD, for instance, has to give profit forecast to the banks because the company made application for a loan or a overdraft facility, etc. Then the director can give this inside information to a third party, and he can use that as a defense. Is where an insider who knows that he or she has inside information and then goes on and encourage or causes another person to deal or discourage or stops another person to deal. Then you commit an offence in terms of the FMA, and there's no defence for that. Section 80 of the FMA deals with prohibited trading practices, and it states basically that no person may either for such person's own account or on behalf of another person knowingly, directly or indirectly use or participate in any practice which has created or is likely to have the effect of creating a false or deceptive appearance of the demand or supply for the or any trading activity in connection with or an artificial price for that. Simply to have known that he or she is participating in a practice referred to in subparagraph A above. And section 83 deems certain trading practices to be in contravention of subsection 1. Now let's look at section 83. One of such practices is approving or entering on a regulated market in order to buy or sell a security listed on that market which involves no change in the beneficial ownership of that security with the intention of creating a false or deceptive appearance of the trading activity or an artificial market price of that security. This kind of practice is prohibited in terms of the FMA. Another practice that's prohibited is what we call improper match trades. Section 83B states that approving or entering on a regulated market in order to buy or sell a security listed on that market with the knowledge that an opposite order or trade at substantially the same price have been or will be entered by or for the same or different persons with the intention of creating a false or deceptive appearance of trading activity or an artificial price for that security. Again, this kind of practice is prohibited. Another practice that's prohibited is what we call pump and dump. It's in section 83C. Approving or entering on a regulated market orders to buy security listed on that market at a higher price or orders to sell a security on that market at a lower price for the purpose of unduly influencing the market price of such security, which is basic market manipulation, right? And that is not acceptable in terms of the FMA. Another action that is prohibited is marking the close. Basically means that you're approving or entering on a regulated market in order at or near the close of the market, the primary purpose of which is to change or maintain the closing price of a security listed on that market. Then the final practice that's not acceptable is approving or entering on a regulated market in order to buy or sell any security which order will be included in any auction during an auction call period and cancelling such order immediately prior to the auction matching for the purpose of creating a false or deceptive appearance of trading or an artificial price for such security. Now let's look at false, misleading or deceptive statements. Section 81 states that no person may directly or indirectly make or publish in respect of listed securities or in respect of the past or future performance of a public company any statement, promise or forecast which is at the time and in the light of the circumstances in which it is made false or misleading or deceptive in any respect of any material fact and which the person knows or ought reasonably to know is false, misleading or deceptive. or any statement, promise, or forecast which is by reason of the omission of a material fact rendered false, misleading, or deceptive, and which the person knows or ought reasonably to know is rendered false, misleading, or deceptive by reason of the omission of such fact. So very important, guys. Must make sure that you do not give false and misleading statements. Um, a person who has made such statement as contemplated in subsection A, which is, a false or misleading statement, and who was unaware that the statement was false, misleading, or deceptive, and who now becomes aware of the fact that such statement is false or misleading, must immediately, without delay, publish a full and frank correction with regard to such statement, and a person who contravenes subsection 1 or fails to comply with subsection 2 commits an offence in terms of the FMA. Now let's look at the penalties or the sanctions for market manipulation. The DMA can refer the matter to the Enforcement Committee. Administrative penalties can take into account the same factors as are applicable to an insider trading offence, but the penalties are unlimited. The FSB can refer market manipulation for criminal prosecution or prosecute it themselves, so that, they've got a choice. They can criminally sanction the same as for insider trading, and there's a 50 million fine or imprisonment up to 10 years is a possibility. And that is all from my side. Thank you very much.
Thank you, Annalie, for that insightful presentation on insider trading. Today, I will be presenting a topic entitled Flirting with Price Sensitive Information. This presentation shall focus on price sensitive information encapsulated in both the equity and debt listed market, together with practical examples thereof. In addition, the main factors when determining whether information is price sensitive or not will also be discussed. I will also look at the issuer's responsibility when faced with price sensitive information in terms of what is required from the JSE listings requirements. Annalie has touched on the definition of price sensitive information in her presentation, and I will not delve too much into it, but I would rather hone into one particular element within the definition of price sensitive information, and that focuses more on the materiality element. Looking at this materiality element, it is assessed both qualitatively and quantitatively, and that means that there is no firm figure that is or has been set for any issuer, as this variable varies. One can also establish whether information is likely to have an effect on the company's share price. It will be considered material if a reasonable investor considers it significant in making an investment decision. Consideration should be given to whether the information has the potential to influence the economic decisions of investors in relation to the company's shares. Now, the JSE has issued a practice note 2 of 2015 that provides guidelines to directors when making such assessment. Information that has the potential to influence the economic decisions of investors include the following, and you can see these from the slide. They include assets and liabilities, performance or expected performance, financial conditions, course of business, major new business developments, and information that has previously been disclosed to the market. An issuer may face unexpected or significant events that can affect the prices and market activities. It is thus vital for issuers to make a prompt assessment of the likely impact of these events on their share price and obviously to decide consciously whether the information would be price sensitive and needs to be disclosed. Some common examples of an event that could lead to an issuer having price sensitive information are the following. Regular recurring matters, for example, financial results. And within this, it could include, for example, news of earnings or losses, dividends, and this could include changes in dividend policies, the declaration of a share split, or the offering of additional securities, etc. Appointments and resignations of executive directors as well, information about strategy or even changes to the company's strategy, loan agreements that the company enters into with third parties, share repurchases, significant and material disputes or even litigation that is pending, material fines that were imposed onto the company, as well as regulatory sanctions and proceedings. And also the last one is exceptional matters, and that could include either acquisitions or related party transactions. Now, the above list is not comprehensive and is merely for illustrative purposes only. Other types of information may be price sensitive depending upon facts and circumstances. It is important to understand the definition of price sensitive information as it relates to the repurchase by an issuer of its securities. A company secretary is in consultation with the chairman, group CEO, and/or group finance director. They should determine whether the information qualifies as price sensitive with reference to three main factors. The three main factors looking at that particular slide focuses on importance, size, and certainty. Now, where there is price sensitive information relating directly or indirectly to the financial or trading position of the issuer or the issuer's securities, the issuer must, firstly and without delay, unless the information is kept confidential for a limited period of time, release an announcement on SENS providing details of the price sensitive information. Also, immediately after an issuer knows of any price sensitive information and the necessary degree of confidentiality of such information cannot be maintained, or if the issuer suspects that confidentiality may be breached, the issuer must release an announcement on SENS providing details of the price sensitive information to enable investors of listed securities to make an informed investment decision. We can see clearly that the necessity to highlight details of the price sensitive information is of paramount importance. Issuers must make a prompt assessment in determining whether certain events could lead to a leak of price sensitive information and consequently whether an announcement must be released. The repurchase of debt securities is an example of an event that may carry with it price sensitive information, especially in the debt market. However, it excludes marketing activities where the issuer provides liquidity or serves as an intermediary to facilitate transactions between buyers and sellers of debt securities. This is commonly known in the market as market making activities, where an issuer intends to make an offer which is open to all holders of debt securities in respect of all or part of their holdings to repurchase any of its debt securities. Then, Section 6.37 of the debt listings requirements provides that the issuer must release an announcement on SENS. Now, this offer period must be open for at least 15 business days. While the offer is being actively considered, ensure that no dealings in the relevant debt securities are carried out by or on behalf of the issuer or another member of its group, associate, or subsidiary until the proposal has either been submitted to the JSE or abandoned. Finally, it is important that the issuer notifies the JSE of its decision to proceed with the offer to repurchase. Since a repurchase of debt securities can trigger an event that could constitute price-sensitive information, issuers should announce within the allotted time. This next slide focuses on examples of price-sensitive information that happened closer to home. Looking at the first example, the JSE imposed a 1 million rand fine on Steinhoff Investment Holdings for breaching the listings requirements. The JC also said that the company, Steinhoff, had twice failed to announce ratings downgrades, which was a strict breach of the listing conditions that require price sensitive information to be published without delay and provided to all investors and the general public simultaneously. Also, a Pretoria businesswoman was convicted for insider trading, and she was sentenced to a 300,000 rand fine or 5 years imprisonment, as she made a profit of 947,634 rand in 1997 by dealing in 700,000 shares of automakers, which was the holding company of Nissan South Africa, on the basis of receiving price sensitive information that she obtained from the former managing director of Nissan Manufacturing. When issuer approaches the market for the purpose of, for example, a debt repurchase, it should be aware that as it is offering to acquire debt, information about the company, its financial condition, or operations or the course of its business, this could all amount to non public information that could be price sensitive. As such, Consideration needs to be given as to how to manage any material non-public information, and if this must be released prior to conducting any market repurchases, it is important that issuers determine that they are prepared to do so. More so than not, this will be fact specific, and advice should be sought before seeking to engage in one or more buybacks, for example. The general rule is that issuers must inform the public as soon as possible of inside information which directly concerns the issuer or its securities. In this regard, any buyback of outstanding bonds that, if made public, would have a significant effect on the price of such bonds or on the price of related derivative financial instruments, this would constitute inside information. It may also arise either way knowledge of the proposed buyback program itself will constitute inside information, or where the transaction will likely give rise to inside information, such as, for example, a reduction of liquidity in the bonds. Often, circumstances, as I said previously, will be very fact specific, and so it is important for issuers to consult their relevant sponsor before conducting any debt repurchases to help navigate transactions and ensure compliance with the JSE debt listings requirements. The failure to do so may, in all likelihood, result in criminal liability, so issuers want to try and avoid that. On the whole, the new debt listings requirements will go a long way to holding companies with debt instruments closer to the standards that have made the JSE's equity market one of the world's best regulators. This actually concludes my presentation on the topic of price sensitive information. I thank you for joining us today, and please join us for part two of this webinar next week, where we will actually be joined by our guest speaker, Brandon Topham from the FSCA, and he will be giving us an update on market abuse on both a national and international level, and Natasha Petrides, who will be unpacking how boards can balance price sensitive information and good governance in a climate that actually demands that they prioritize both. Please feel free to contact us if you have any questions or queries, and we look forward to seeing you again soon. Thank you.